I guess I can begin now.
Yep,
So my name is
we're live.
Paul Lanois. Fantastic. So my name is Paul Lanois, and I'm going to talk to you today about the GDPR and the European Data Protection Framework. Um, so before we begin, a quick word about me and who I am. So I'm a director at the law firm, sorry, Field Fisher, and I cover the areas of technology law, data protection, privacy, and cybersecurity law. Uh, this is what I currently do, and I work with a number of different companies, tech companies, but also video game companies as well. And before working at Field Fisher, I've worked at a few different law firms in the United Kingdom. I've worked in France, in Luxembourg, as well. And I've also been working in-house at a large Swiss bank. I was based in their headquarters in Zurich and in Hong Kong. And even though I was working at a bank, I also did work on a number of different initiatives in relation to new technologies. So, for example, looking at new technologies such as augmented reality, virtual reality, and also certain apps which were aimed towards children to teach them, for example, the value of saving money and so forth. So I, so even though I was at the bank, I have been working still in the tech world and also, and particularly in the game industry. And today I'm going to talk to you about the European General Data Protection Regulation because I assume that a lot of you are based in the European Union and you may not necessarily know about this European piece of legislation. If there are any questions later on about other topics, other privacy laws such as the California Consumer Privacy Act and so forth, I'm also happy to address those in the questions later on if there are any. So all right then, in relation to uh, data protection laws, uh, as you can see on the slide here, what I wanted to show here is that over the past few months and years as well, there has been an increase in the number of legislation worldwide covering data protection and privacy. Perhaps the most important piece of legislation in relation to data protection is the European General Data Protection Regulation, the GDPR, and that's what we will be talking about here. And the reason why I say it's perhaps one of the most important pieces of legislation in this space is that the GDPR has captured a lot of attention because it applies not only to companies based in the European Union, but it also applies to companies which do business in the EU, companies which are not necessarily based in the EU. So as long as you are doing any type of business within the European Union, then the GDPR applies to you, even if you do not actually have any physical brick and mortar business in the EU. So if you don't have any office in the EU, but because you have European customers, well, the GDPR applies to you. And the GDPR has also inspired a number of different pieces of legislation around the world. For example, in Brazil, there is a new privacy law which is very heavily inspired from the European GDPR. In the US, you have the California Consumer Privacy Act, which is also inspired somewhat by the GDPR. There are lots of discussions as well in other US states to have GDPR law and around the world in other countries, whether it's in Asia or in other regions in the world. There are also a lot of discussions about having data protection laws. And the majority of countries now, 64% of the countries have a legislation in relation to data protection. There is certainly an overwhelming amount of countries who have a law like the GDPR, and that's why it's important to understand how it works. So what is the GDPR? Well, the GDPR, the GDPR is a legislation. Sorry, it's a regulation which was issued by the European Union. It came into force in May 2018, and it applies to all of the European member states, and it also applies to countries which are members of the European Economic Area. And the purpose of the GDPR is to have a harmonized data protection framework throughout the European Union and in a number of different uh, in, the, in a number of different areas, so that there is one single consistent framework which applies. When I say harmonization, I don't necessarily mean that all of the countries have one single set of rules. Unfortunately, that would be fantastic, but then in reality, there is still the possibility for European member states to introduce certain variations and derogations to the GDPR. To whom does the GDPR apply to? And the GDPR applies to organizations which are based in the European Union. So if you are based in a European country, or if you're based in a country within the European Economic Area, or Switzerland and similar countries, well, it means that you have to comply with the GDPR, or in the case of Switzerland, you have a legislation which is very close to the GDPR. And there's no way around it. It's the local law applies, and the GDPR has been applied in those countries. But some of you may say, "Well, that's very nice, but I actually don't have any office in the European Union. So why do I need to care about the GDPR?" Well, the GDPR says that even if you do not have any establishment in the European Union, as long as you're offering goods or services to European residents, or otherwise, if you're monitoring the behavior of individuals based in the European Union, well, you have to comply with the GDPR. And if we look specifically at the game industry, what does it mean? Well, which are targeted towards European residents. So do you offer apps on the European App Store, for example, the European version of the Apple App Store or Google's App Store? Well, if you do, then because your app is available in the European Union, well, you would have to comply with the GDPR. And otherwise, do you monitor the behavior of individuals? This The monitoring of individuals covers situation uh, where you have, for example, any kind of uh, monitoring going on. For example, do you try to track data usage? Do you try to understand how your app is being used? Do you try to do it, for example, in relation to measure performance or to performance of your app or whatever? If that's the case, then you would be classified as monitoring the behavior of individuals in the European Union, and therefore the GDPR would apply to you. Uh, I, I guess we should start with the basics. The basic being, what is personal data? What is actually captured by the GDPR? And under the GDPR, you have a definition of personal data, which is extremely broad. So you have on the slide here, you have the exact definition, which is provided within the GDPR. And it says that any information which relates to an identified or an identifiable natural person, in other words, an individual, then that is personal data. So if I take what is commonly collected in relation to an app, some of you may say, well, we don't collect personal data because we don't have any name. We just have an email address, which may not necessarily contain the real name of a person. So surely that is not personal data. Well, that's not accurate. Under the GDPR, it says here, as long as you have any identifier such as a name, an identification number, location data, an online identifier, or other factors which are specific to an individual, then that's personal data. So even if you have collected just email addresses for the login of the individual. So an email address, it may very well be Fox 2019 at outlook.com, for example. You would say, well, there is no name there, so it's not personal data. Well, actually, it is personal data under the GDPR. It is personal data because you are collecting information which relates to an identifiable person. You may not know who is hiding behind the email address, but that person is identifiable. You know it's that person can be reached through that email address. The same goes with other types of information which may be collected by your apps. For example, do you collect device ID, particularly if you want to have advertisements which are included within your mobile apps? Well, those type of device IDs would also fall within the definition of personal data. An IP address as well, that's personal data. It's an online identifier and so forth. So the reality is that personal data is extremely broad, and it is extremely likely that you are actually collecting personal data in relation to a number of apps which you may be working on, particularly if you are working on mobile apps. Now, the second point that I wanted to cover as well is the definition of processing. So the GDPR covers the processing of personal information and personal information or personal data. And the definition of processing under the GDPR is extremely broad because it covers the collection, the recording, organization, the structuring, storage, adaptation, alteration, retrieval, consultation, use, disclosure by transmission, dissemination, and so forth. So basically, any type of operation that you conduct on data, that's processing under the personal data. So even if you're not the entity collecting the information from the individuals. But if you are a third party, for example, let's say you are you are not a game developer, but let's say that you work at a company which provides the advertisements to be incorporated within the game. So you own an advertisement platform company, and you propose to have your platform, your advertisements integrated within a game. Well, even if you say that you're not collecting the information yourself, it's the game developer who is collecting the information on your behalf. Well, you are still doing some processing under the GDPR. And because the definition of processing is extremely broad under the GDPR, this also means that in order to comply with the requirements under the GDPR, you need to actually understand and keep track of the data that your organization is collecting, processing, and using. If you don't have any idea of where you store the data, what you use the data for, and so forth, it's going to be extremely difficult for you to comply with your obligations, whether it is under the GDPR or other pieces of legislation covering data protection. And in order to keep track of the data, this means that you have to conduct a data mapping exercise. You need to have a clear picture within your company of what is being done in relation to any data that you collect, that you use, or that you transfer, or whatever. Uh, Moving on to the next slide, in relation to the lawfulness of processing. So what the GDPR says is that uh, now that you have collected from individuals, you want to conduct certain processing activities, you want to do something with the data. Well, under the GDPR, it says that you may do that, but you need to do it within one of the different lawful processes which I mentioned on this slide here. So the most common the most common legal basis, sorry, for the processing of data would be consent. But it's not the only one. It's not the only one because you are, of course, allowed to collect data and to use it for other legal grounds. For example, are you performing a contract with the customer? Are you complying with a legal obligation and so forth? The reason why I wanted to mention the different processing legal basis is that uh, there has been a lot of misunderstanding in relation to the GDPR. A lot of people assume that you need consent for everything. And even though it's true that consent is an important legal basis for the processing of data, it's not the only one. It's not the only one because uh, there are other grounds which I mentioned here on the slide, which are just as important and which you may instead have to rely on to conduct your activities. And in fact, if you rely on consent, one of the issues you have to bear in mind as well is that consent from an individual means that the individual has agreed to you to process the data, but consent is not forever. Consent is limited in time. Consent can be withdrawn as well. So I'm a customer and I tell you today, you know what, fine, I allow you to share my data, and tomorrow I say, you know what, actually I changed my mind. I don't really want you to process my data. I want you to stop all the processing that you're doing in relation to my personal data. Well, that's possible under the GDPR. Consent can be withdrawn at any time. And if the customer withdraws consent, then it means you have to stop everything and you don't have any other possibility uh, to use the data. And that is why it may be important for you to take a look at whether there are other legal grounds which actually do apply, which would explain why you need to collect the data. For example, if a customer purchases something from you, well, you are executing a contract. And of course, if the customer says to you tomorrow, even though I just bought this item from you, I I withdraw my consent. That wouldn't work. It wouldn't work because you still need to keep you still need to keep the data for the performance of the contract so that you can deliver the item, and you also need to keep traces of the order in order to comply with your own legal obligations as well. So this is why it's important as well to look at the other grounds for the processing of personal data. And uh, on this slide, you can see common uh, a common example, I would say, of consent which is collected via an app. And I chose you two real life examples of an app asking customers to provide consent. So consent, it's not really that difficult. It's asking customers to agree to accept. It's just a matter of clicking the button after providing the necessary information to the individual. However, and that's the reason why I also picked these examples, is that uh, these examples actually show an issue in relation to the consent. If you can see the notice which I've enlarged on the right, it says that this company is collecting and using data, and this data is collected to enable core gameplay, fulfill purchases, and so forth. And then it also says, well, in order to support our games, we are also asking you for your optional consent to the collection and sharing of data for ad personalization and measurement by our partners. And the issue here is that you have everything bundled together. So it's consent. They're asking basically here for consent in relation to uh, core gameplay, and also for consent in relation to the ad personalization. The issue is that under the GDPR and also under other recent data protection laws which have been enacted recently around the world, the issue here is that in relation to consent, consent needs to be specific, and it needs to be clear to what you're agreeing on. And in this case, it's not really very clear, right? Because uh, as a customer, when I read this, I'm not really sure what I'm agreeing to. Is it just the data for the core gameplay, or is it advertisement purposes? And let's say that I agree to the core gameplay data usage, but I don't want to have advertisement. Uh, you're not able to you're not able to give any opinion here. So that's why it's an issue, because in this case, this notice would not comply with the requirements of the GDPR. It would not comply with the requirements of the GDPR because everything is bundled together. And uh, as I mentioned, consent needs to be specific. And this is not to say that you necessarily have to that you need to have 50 different pop-ups or whatever. What I'm saying here is that because the notice talks about optional consent in relation to advertisement, it's not really optional, because here I don't have the possibility to say, well, I agree to one and not to the other. It's all or leave it. And there has been recent guidance from data protection authorities in a number of countries recently, stating that they are no longer fine with such notices. They are saying now that you need to have consent for the different types of data usages. And in this respect, the French Data Protection Authority, the CNIL, actually issued a decision in relation to Google, and that was the issue as well that the French Data Protection Authority had in relation to Google. So they fined the company 50 million euros, and they said the problem was that the in order for the user to be able to provide consent, you need to know what you are agreeing to, and you need to be able to make a choice. But then, if the information is scattered everywhere, or if you are required to agree to everything as a bundle, make any choice or whatever, then you have a problem under the GDPR, under the data protection framework. I'm not sure if there are any questions at this stage, or if I should just go ahead. Let me know if there are any questions. I'm happy, of course, to answer any questions that anyone may have at this stage. Nope. The questions. Okay, then. So I'll just go ahead. So on this slide, you can see the key principles of the European General Data Protection Regulation. You have 7 key principles, and this isn't meant to summarize the whole of the GDPR. Of course, instead it's supposed to show you what are the key principles that you need to be mindful of in your compliance journey. So the first principle under the GDPR is lawfulness, fairness, and transparency. This means that you have to have, of course, a privacy policy. You need to be able to disclose to your customers what you are doing with the data. You need to be transparent about it. You cannot just have a black box, if I may call it that way. You cannot have a black box where you just collect information and you don't tell your customers what you're collecting, why you are collecting the data, and what you're using it for, and with whom you are sharing the data. You have to be transparent. So this is one of the key requirements under the GDPR. Uh, lawfulness of the processing, I mentioned that earlier as well. You are able to collect, to use data under the GDPR, of course, but then you need to be able to do it under a lawful process, which I showed on the one of the previous slides. So you need to have a legal basis for the processing of the information. That is one of the key principles of the GDPR. The second principle of the GDPR is purpose limitation. So this means that if you collect data for a specific purpose, you have to be using that data for that specific purpose and not for something else. So let's say that you collect data on a website uh, in, in order for customers to participate in a competition, and that's what you say. You tell the customers that you are collecting their email addresses so that they can participate in an online competition. Then this means that you have to use the data only for the competition. You cannot then just use the data for something else. Uh, that's the concept of purpose limitation. You have to do what you say that you do. Now, some of you may be wondering, well, what does it mean in practice? Does it mean that I can only collect information for one specific purpose and I can't use it for something else? Well, yes and no. You can use, for example, the data that you collect for the competition for marketing purposes. But then, if you want to do that, you will need to get specific consent for that. So the customer has to agree that he agrees to the use of the information for marketing purposes. So in practice, this means that if you have an online competition, for example, where you collect email addresses from customers, well, you would need to have different boxes that the customer can tick to provide consent for different purposes. So the customer agrees to the use of the data for the competition, but then you will need to have another box in relation to the usage of the data for marketing purposes. So that's what the purpose limitation means. It means that you are limited to the purposes that you disclose, and of course, for each different purpose, you need to have a lawful basis for the processing of the data. The third key principle of the GDPR, data minimalization. This means that you should only collect the information that you need in order to conduct the purpose. Uh, so what does this mean in practice? It means that you should not overreach and try to collect other information which you do not strictly need. For example, in relation to an online competition, yes, it is useful to get information such as the name and the email address so that you can contact the participants of the competition. But then, do you really need information such as the social security number of that individual? Do you need the driving license number? Do you need the national ID number? Whatever. Well, I would think it's extremely difficult for you to explain why you would need such information uh, for the competition. And data minimalization means that in relation to every piece of information that you collect, you have to think, do I need the information and why do I need it? And uh, if the grounds are extremely shaky, then it means that you probably do not need the data and you should not be collecting that data for that purpose. The next key principle of GDPR, accuracy. This means that you have to ensure that the data that you collect is accurate, and whenever possible, the data should be kept up to date. So this means that you have to update the information that you hold to the extent that you are aware, of course, of any change. And it also means that customers are allowed to tell you to update the information that you hold in your records. The next key principle of GDPR, storage limitation. This means that there are also certain uh, limitations which are imposed under the GDPR in relation to what you can do with the information in relation to the storage, for example. How long do you keep the data? Certainly, it may be tempting, especially because data storage is so cheap nowadays. It may be tempting for you to say, well, I would like to keep the information forever because I don't know, maybe it might be helpful. Maybe not today, but maybe in a couple of months' time, or maybe in 3 years' time, maybe that information will be helpful. The problem is that under the data protection laws, there are also limits on how long you can actually keep and store personal information. You cannot keep the information forever. And from a compliance perspective, I would also add that it's in your interest actually not to keep data for too long, because if you keep data for a long period of time, well, it's not really going to be quality data. The data will be out of date, so you will not be able to make any useful decision out of that data. And then there is also the issue that you will need to keep and hold the information secure. You have a number of security obligations as well, which applies to the data that you hold. So if you keep data forever, this means that you are also bound by the number of different security and notification requirements in relation to that data. And do you necessarily want to have it? Probably not. You probably don't want to have to be subject to those obligations forever, because it means that you also have to maintain and update the security in relation to such data. Because if there is a data breach and the data that you hold is being leaked, then that's when you're going to have a lot of problem, especially if a regulator can show that you've been holding on to information for a very long time for no reason, and that practice has led to customers' information being at risk. The next principle of GDPR, integrity and confidentiality. This ties back again to the storage limitation principle that I just mentioned. You have obligations under the GDPR and also under data protection laws around the world. You have obligations in relation to keeping the information secure. Integrity, you have to make sure that the information is not being changed or amended in any way from an unauthorized person, for example. So you have to protect the information that you hold. Um, and the reason why there is this distinction between confidentiality and integrity is the fact that confidentiality simply means that you have to keep the information away from unauthorized persons. But then integrity means that you also have to make sure that the information is not being changed or altered in any way. So let's say that your company suffers a ransomware attack. So you have a ransomware which has been deployed on your devices. You're no longer able to use your computer because your computer is locked. And so some of you may say, well, okay, the information is locked. I can't use it. The hacker is telling me that in order to be able to unlock my computer, I need to pay X amount of Bitcoins or whatever. And I can't use the computer. And because the computer is completely locked, it means that no one, even the hacker, doesn't have access to the information because I just pull out the internet plug and there is no internet connection going on. That may very well be. Maybe the hacker doesn't have access to the information, but then what the data protection authorities have been saying is that there may not have been a breach in the confidentiality obligation under the GDPR, but then you have this integrity obligation as well. So if the data is unavailable and it cannot be accessed by you, and the data has been locked, it has been encrypted by a hacker, well, you have a breach of your integrity obligation, and this means that you would have to notify the data protection authorities in relation to that data incident. The GDPR in particular imposes very strict requirements in relation to a data incident. So if you become aware of a security incident which impacts individuals, for example, the information that you hold, you have your database which has been hacked, and hackers managed to to get access to it, or otherwise you are a victim of a ransomware attack or whatever. Under the GDPR and also under the laws of many different countries, you actually have an obligation to report that incident to the relevant regulator, and depending on the circumstances and depending on the country, uh, there, there there may very well be as well an obligation to for you to notify the impacted individuals. So this is something that you have to be mindful of. And unfortunately, many times uh, there are uh, there are lots of companies who say, well, that's fine. I mean, data breach is something that I prefer not to think about. That's the disaster scenario. We prefer not to think about it until it actually happens. The problem is that under the GDPR and also under other data protection laws around the world, you have very strict timeframes as well to notify the regulator. Under the GDPR, you only have 72 hours to notify the regulator from the time you become aware of the incident. And this means that if you haven't thought about a process, what to do in case such a security incident happens, you will probably not have enough time to handle it when the incident happens, because in practice, if you have to figure out then what do you do, who do you notify, who do you need to talk to within your company and so forth, it does take more time than that, and that's why this is something that I would recommend everyone listening to this presentation to look at beforehand, so that you don't find yourself in breach uh, of the GDPR or other data which exist in your country. And then finally, the last key principle of GDPR, accountability. This means that accountability. So you are there are a number of obligations which are imposed on the organization which is handling the personal data, and it means that if you do not handle the data in compliance with the different requirements of the GDPR, well, you can be held liable, and severe penalties and fines can be imposed on your organization pursuant to the GDPR or other data protection laws. In relation to privacy as well, one of the areas which have previously been overlooked by a number of organizations in the gaming industry, I would say it's in relation to children's privacy. Children's privacy, because when we're talking about video games, well, it means that the audience is not only adults, but the audience would also include children. And in relation to children, there are a number of different requirements which apply as well. And if you, for example, one of the requirements is that in relation to children, well, you would need to get the consent of the parents, because a child is too young. A child is not able to provide a valid consent, and there have been already a few significant cases in relation to children's privacy. For example, in the United States, there was this big decision by the Federal Trade Commission against TikTok, and the penalties were huge as well, and it was the I'm sure most of you are aware of or have been using. And as you may know, TikTok is not a US company, but then because the audience is international, because they have a large number of users in the United States and around the world, this meant that the the U.S. privacy laws also applied to TikTok, and this means that you have to comply with the different requirements which apply whenever you are handling information relating to children. So there has been this TikTok case. There has been also a case in relation to YouTube, in relation to content, video content, which was available online and which were designed and targeted towards children. Uh, the next slide. This is a key. This is the overview of the key rights which apply under the GDPR to data subjects, so to individuals. A lot of those rights are not new in the sense that those rights already exist in a number of different countries, but then those have been reaffirmed as well under the GDPR. So, for example, the right to be informed. This means that as a customer, you have the right to request that the organization provides you information in relation to what data they have about you. And under the GDPR, you also have a strict time frame to respond to such requests. You have 1 month. And if you do not comply with that request within the specified time frame, then you could also be in trouble under the GDPR. Right of access. Customers, they have the right to request specific information that you hold about them. The right to rectification. This means that the customer can request that you change information that you have about them in your files. The right to evasion means that customers have the right to request that you delete certain information that you hold about them. This is a tricky right, I would say, because some people misunderstood this right as being an absolute right. They believe that if a customer says that I want to erase the data, then I have to just erase without any further thought. And that's not what the GDPR is saying. The GDPR says that certainly customers have a right to erase information relating to them, but then these rights that individuals have to be balanced with other rights which may exist. Maybe you may have a legal obligation to keep the data. Maybe there are other legal grounds for you to keep that data, and this means that it's not always clear cut what you can do or should do when there is any request to erase the data. Instead, you need uh, to to look at the data that you hold in relation to that individual, and then you need to determine whether or not there is an obligation for you to erase that data before you actually erase the data. In relation to the right to restrict processing, this means that under the GDPR, a customer has the right to ask you to stop processing. So this is not the same as erasure, because the customer is not saying, I want you to erase the information. Here the customer is saying, well, you can keep the information, but then I don't want you to use the data for a specified purpose. So that's a right which exists under the GDPR. Uh, um, you have also the right of data portability. So this means that a customer can say, well, I would like you to provide me all of the data that you hold about me, but I want it to be in an electronic format that I can then use and that I can provide, for example, to another service provider. So this is particularly useful, for example, in relation to cloud companies where you may have a lot of data which is already stored online in the cloud, and maybe you want to migrate to a different service provider. So the right of data portability means that you would be able to ask one company to give you all the data that they hold about you in a commonly used electronic format, and then you can then provide this this data to another service provider, for example. And then you also have under the GDPR, you also have the rights relating to automated decision making and profiling. So this means that you under the GDPR, you if a company is making any decision based on an automated and this automated process has a legal impact on you. For example, let's say that you're applying for, I don't know, a loan or whatever, and let's say that the company is simply applying an algorithm in order to determine whether or not you should get the loan. This under the GDPR, you have a right to say, well, uh, I want you to, instead of using this algorithm, instead of using this automated decision making process, I want a human to review and uh, to review my file, and so that the decision is not based only on a decision made by the algorithm, but it's a decision made by a human being. And some of you may wonder, well, why has this been created? And the the intention of the legislator under the under this sorry, the intention of the legislator when they created this right under the GDPR is to ensure that because in many cases, because automated decision making uh, processes has in some cases led to decisions which have been made based on the wrong basis. For example, maybe the name is similar, and but then the information you're looking at is relating to a different individual, or maybe the algorithm may be having some kind of inherent bias or whatever. So the intention of the legislator here is to say, well, uh, we are not preventing companies from making any automated decision making. Of course, this is something which is important for a number of companies. They may want to speed up processes. They want to have something done through artificial intelligence and so forth, and that's perfectly fine. But then there should also be the possibility for customers to say, well, I don't feel comfortable with this, or I disagree with a decision, and I want a human to review my specific file. Okay, then. So this is all I wanted to say in relation to rights. Before I go on, I wanted to check if there are any specific questions yet, or if I should just go ahead. No questions? Okay then. So I will go ahead with the next slide. Uh, okay. So some of you may wonder, well, okay, well, you talked a lot about what is imposed under the GDPR. That's nice, but then why should I comply? I'm a small indie game developer. We have extremely limited resources, and why should I spend resources to comply with the GDPR when we have so many different issues to look at? We don't have the resources of a AAA game studio. So why should I care about the GDPR? Well, the first risk, of course, is the risk of fines. The data protection authorities around the world have shown that they are taking privacy very seriously, and they are they have already launched a number of different investigations around the world against companies to ensure that they comply with the obligations laid forth under the GDPR. So, in addition to fines and criminal sanctions, well, in a number of countries as well, you may have different issues such as actions. Maybe a customer is unhappy as well with what you're doing, and either that creates its own, or that's not possible. Many times, what happens is that you have customers who would then report the alleged wrongdoing to a regulator. So this is something which we have seen a lot as well, where a lot of information is being provided by customers to regulators so that the regulators initiate an investigation. And so this is the reason why the data subject rights, the individual rights that I mentioned earlier, those are extremely important as well, because many times what is happening now is that you have customers who would be sending requests to companies saying, I have the following rights under the GDPR, and I demand that you provide me the information. And the problem is that if you do not take that request seriously, it means that the customer can then, after the specified time frame, they can just go to a regulator and say, well, I made a complaint to that company, and the company did not respond within the GDPR timeframe. Please investigate. This is something that happens a lot, so you have to be careful about that, especially since the GDPR has attracted a lot of attention around it over the past few months. And the GDPR has been around since 2018. There has been a lot of media attention about the GDPR, so a lot of people, even those not based in the European Union, are aware of the GDPR, and we are seeing as well a lot of individuals who are invoking GDPR rights, even though they are not based in the European Union. So this is something that you have to be mindful of as well. And in terms of financial risk as well, in addition to the fines and criminal sanctions which may be imposed by a regulator, there may be other sanctions which may be imposed by a regulator, meaning that you would have a lot of bad publicity, and this is something as well that you should be mindful of. Bad publicity, not only in the sense that you would be in the news for all the wrong reasons. It also means that many times, whenever you're having discussions or negotiations with a supplier or another game studio or whatever, and you want to work with somebody else, this is something which often comes up as well. If there has been a sanction which has been imposed against you by a regulator under data protection laws, many times what we're saying is that companies walk away. They don't want to be involved with you because they are scared to be associated with the and this as well that comes up a lot in contracts. If you want to get a contract with, for example, if you want to get a license for a famous intellectual property, let's say you want to I don't know, you want to use a famous IP like I don't know, Jurassic Park or whatever, and in order to get the license to do it, you need to negotiate with the rights holder, and many times as well they would ask questions in relation to data protection. Are you under investigation? Has there been any data breach? Has there been any security incident? Has there been any data protection allegations made against you, and so forth? And many times, a lot of companies would just walk away if they believe that you are under investigation for data protection, because the penalties can be extremely high. Operational risk as well. Data protection authorities are able to impose prohibitions on the processing of information as well. So this means that if they do issue such a prohibition, this means that you can't use the data which is under the prohibition. So they can tell you, well, you are forbidden from using that data. You have to delete it immediately. And if that's the case, well, yeah, you have to comply with that order. There have been as well a number of organizations who had a number of issues internally after huge data breaches took place. There have been multiple cases actually of CEOs or CIOs who have been fired and dismissed following security incidents which were highly mediatized. So that's about all I wanted to say today for this presentation. You can find my details here on the last slide. So feel free, of course, to contact me if you have any questions or if you would like to discuss anything further. I guess if there are any questions now, we can also we may have time to address those questions. But then, if you are shy for some reason and you don't want to discuss this on the air, feel free to send me an email. I guess one of the points I can add is the fact that so in this presentation we talked a lot about the European GDPR, the European Data Protection Framework, but then the uh, a lot of the principles that I just mentioned also apply to other countries. For example, for those of you who are targeting apps towards Asia as well, well, there has been a lot of developments in the privacy space in Asia. There has been a lot of yeah, I would say interest in Asia as well to adopt new enhanced privacy laws, which are more or less inspired by the GDPR. For example, obligations, the obligation uh, to to disclose, to notify the regulator of a security incident. Interest as well in relation to the data, the individual rights that I mentioned in the presentation. For example, the rights for individuals to ask information, to get access to information, and so forth. So, even though in this presentation we cover the European GDPR, this doesn't mean that everything that I said only applies to Europe. There has been a lot of attention worldwide as well to adopt something more or less similar. Now, some of you may say, well, what should I do then in order to comply with those different laws? And that's also the reason why I chose to focus this presentation on the European General Data Protection Regulation, the GDPR, is because at this stage, at least, it's probably one of the data protection laws which exist in the world. And it means that if you have a process in place to comply with the GDPR, for example, do you allow, for example, do you have data mapping that I mentioned earlier? Do you understand the different data that you hold, that you process, that you use, and so forth? Do you have a good framework in relation to the sharing or transfer of personal data to comply with the GDPR? Do you have a system in place to comply with individual rights that customers may have, and so forth? If you comply with all of the provisions under the GDPR, then most likely you should not have too many problems to comply with other data protection laws. However, this doesn't mean that you should only look at the GDPR. For example, if you have a lot of business in the US, in California, well, the California Consumer Privacy Act does impose that you disclose certain specific information which go a bit beyond the GDPR. So you have to be mindful as well of local specificities. Okay then. I think we have less than 3 minutes left anyway, so uh, I guess I'll leave the floor open for any questions. Otherwise, that's it for me.
Well, thank you, Paul.
Thank you very much for
Yeah,
having me.
it was a great presentation. We had a couple of people over Facebook. Well, especially for us Europeans, this is getting pretty late already, but for
Yeah.
but well, it's now also on video, so people will can find it on the social media and later on the YouTube too. So
Yeah.
it will keep living even when the other are sleeping. Yeah, the room is gonna close. So thank you, Paul. Thank you, everyone who were watching this. This was the last presentation of today. So thank you.
Thank you.
Have a wonderful day over there.
Thank you, and good night.
Thanks. Catch you later. Bye bye.
What time is it over there, by the way?
Now it's just past midnight.
Oh, okay. Yeah, it is late.
Yeah, it's well, yeah, 15 past 12. Okay. Bye bye.
Thank you. Bye.